I want to tell you, believe it or not, I'm going to tell you about a dream I had last night. And this is actually true. I've been watching a lot of HGTV because it's really remarkable to watch people build houses, and I love demolition and watching them learn how to cook or garden. And there are no commercials if you buy, if you buy it online. It's just, anyway, I feel like a kid in a candy store. I can't get enough of it. So you'll understand when I tell you that last night I dreamt that in my backyard, I had these 2 life-size doll houses, sort of children's playhouses, really. We could fit in it, but they were clearly for kids. And they had just been built out of wood, and one was entirely painted green, and the other one had yet to be painted. And this is so ridiculous, but and then I looked, and over the green one, there was a sign over the doorway that said "The House," and the brown one, the wood one that was unpainted, was the Senate. And I thought, damn, Zoe, you're really taking this seriously, aren't you? It's been quite a week, an exciting week, and I really want to welcome everybody here. 2 of my circles of women are all here. My Long Beach Suffrage 100 that I love so much, and my home away from home, Nevada Now. So with that, Jerry's going to start our program today, and I'm so happy to see all of you.
So we usually start off, we're doing our joint meeting today with our friends in Long Beach, as you mentioned, the Long Beach Suffrage 100. Am I saying that right, Zoe?
Yes.
And we have Nevada Now members, and we have people from around the country. I've noticed some really amazing ERA activists are joining us as well. So this is exciting. And usually I introduce my board. We've got Trisha Methner. She's our executive vice president. Eva Love, and most of you have met when we got started. She's our vice president outreach. Madalena Robertson is our vice president media. Sue Birch is a woman of many hats, as everyone knows. She's our legislative action vice president, our Nevada Now PAC treasurer, and she's chair of our legislative committee. So she's been wearing lots of hats and been so helpful. And we have Lenore Briley. She's our Nevada Now treasurer. And our new secretary, Michelle Maese, is there. I'm glad everybody's waving. So I love our board. I just like to introduce because it's all volunteer and they're hardworking. So I'm not sure. Oh, good. Even since you didn't have a chance to mute everybody, we usually do that first. But so we've just kind of started off that way. So I also wanted to welcome everybody, and we wanted to start the program. I was checking my phone because I don't know if Senator Spearman can make it. Her brother passed away yesterday, and I said if she's on a family call right now, so she may join us later. But we wanted to start the program just with a mention that this is the weekend, the 4-year anniversary of Nevada ratifying the ERA. We're also proud of this part we took in getting this activism going again. Jeanette Dean is here, and Jeanette, if you had a minute to just say how exciting it was, and looking back 4 years later, with a lot of the people from Nevada that are on the call today were there. Donna West has been posting wonderful pictures of 4 years ago. So if you just have a minute so we can kind of have that in our minds as we get our program started.
Sure. So it's been a wonderful 4 years, but it was 3 years of effort to get the ERA passed. It had last been introduced in Nevada in 2009, but due to a Republican majority at the time, they felt it wasn't going to get through, and they got tied up on budget issues. But I was an intern in 2013 and had worked with Senator Spearman and other legislators. I was a mid-career student and did a 20-hour internship to follow up on a lot of my activism with different movements for climate and against foreclosures and so forth. And we were working on other things in 2013. We were working on Citizens United, renewable energy. And in the summer of 2014, I got a call from Carson City Democrats saying there's a woman that wants to meet with some strong activists in Nevada about the ERA. And I said, well, the ERA, isn't that done? And they said, well, she'd like to meet with you. So I met with her. We had a little bit of a rally. I started looking into all the women's groups in Nevada, and I knew we had to get this done. And PDA Action, Progressive Democrats, this was on their platform. They'd been wanting to get it done too. So we all started, a handful of us started strategizing. And I said, Senator Spearman is just such a wonderful, powerful social justice champion. We need a woman of color to lead on this. And she is just phenomenal because the movement was primarily led without a lot of inclusion. And we knew that had to change. And I gave Senator Spearman a call and she said, yes, I'm in, count me in. And so we started getting support from Reid that summer, and we got AAUW involved, all the groups, NAACP, and we just started, we worked on the election. We lost the majority in both the House and Senate. But we said, we've still got to push this. More people have to know about it. Let's do the groundwork in 2015. And if we can't get it through, we'll be ready to move ahead in 2017 if we win back the majorities. And we did get a little further than we thought in 2015 with Republican Senate Committee Congresswoman Patricia Farley, who really started to understand the necessity of this. So we weren't able to get it out of committee, but we were about to with perhaps a 3-2 or 4-1 vote, and the Senate Majority Leader Roberson yanked it off the committee hearing that very morning. But we persevered, we persisted. The Women's March was 2016 after Trump, and we just kept snowballing the support, and that's when it happened, and it went from SJR 16 in 2015 to Bill SJR 2, and that shows you how serious Senate Democrats and House Democrats were. And again, we reached out across the aisle. Many had such trouble opposing it, they had to fall back on the states' rights argument because they knew we had them beat on a lot of the ethical issues. So yes, we got it done. And then I asked Senator Spearman, would she be willing to go to Illinois, because I wasn't going to be able to go. And I said, we've got to help each other's state move forward, just like ERA Action was doing with a lot of calls in different states. And we knew other states were trying and trying. So she went to Illinois, helped a lot. And then when they passed it, wonderful Stephen Anderson, who'd been a bipartisan, strong advocate, I asked if he would go to Illinois and help convince a few more Republicans. And he said he was willing to on an ERA action. And then they both kept visiting other states, and the grassroots activists also did. And I do a lot remotely, but I was able to be in Virginia 10 days for the ratification last January 2021. So yes, the momentum continues, and we will keep at this until we see it published in that Constitution.
I should have my copy with me. Yay.
Yay.
So we celebrate today, and that's what we wanted to have that in our minds as we talk about what we're going to do going forward. So there you go. Wonderful. I've got mine on my bookshelf in the other room. So thank you so much, Jeanette. So I get to introduce someone. I'm in the middle of reading her book right now, Julie Suk. She's, I've seen her, I first heard her at the NOW conference in Minneapolis, at a conference we had. She had a workshop, and just loved everything I heard about her. She recently joined us for a planning meeting for our ERA Coalition committee meeting, and helped us talk about next steps. And so I'm just so excited to have you here. For those of you who have not met Julie before, she's a professor of sociology, political science, and liberal studies. Well, thank you, Zoe, at the Graduate Center of the City University of New York. She serves as a dean of the master's program. She's also a visiting professor of law at Yale Law School. She's a scholar of constitutional gender equality in the United States and around the world. As Zoe is showing you her book, We the Women, the Unstoppable Mothers of the Equal Rights Amendment. It tells the history of women who created and championed the ERA. And in her book, she explains how the ERA can address issues such as pregnancy discrimination, sexual harassment, equal pay. And one of the questions we often hear is, what difference will the ERA make in our lives? And will it make a difference legally? And so I'm interested in hearing, the next steps that Julie feels we should take, and also the difference it'll make in our lives. So we welcome you, Julie. It's wonderful to have you here. And it's good to see you. Can we get you unmuted? There you are.
Thank you so much. So it's wonderful to be here with you. And Jerry, would you just like me to talk now, or would you like to introduce?
Nope, it's all you. We want to hear what you have to say and talk about your book.
Okay, great. Well, it's wonderful to see all of you. And thank you so much for those of you who've been reading my book. I wrote this into the chat, but if you get the book or gift it to someone and would like a signed author book plate, my email is in the chat. You can send me an email and I will make sure that you get a personalized author book plate from me. You do need to give me your address and who it's for. And I'm very happy to do that. My book was released during this pandemic, and I did one author signing and book talk in a park around the Suffrage centennial. But beyond that, it's just been Zoom, Zoom, Zoom. And it's been nice because I was able to do a book talk in Australia, of all places, on Thursday, and reach much wider audiences. And I'm so happy to be with you in Nevada. And I think that's one of the silver linings of the pandemic. And I want to talk a little bit about how I'm also very thrilled to appear with one of my sheroes as a scholar of employment discrimination law and constitutional law, Lilly Ledbetter. And I just cried reading your book, Lilly, because one of the things that Lilly Ledbetter's story reminds us of, and is directly related to the Equal Rights Amendment struggle, is the question of time. That is, this real issue in the equal pay case that Lilly Ledbetter brought was about how we should think about time and its relationship to the idea of having the rule of law or fair play. Because as we understand it, deadlines and statutes of limitations are very similar. And in fact, the late Justice Ruth Bader Ginsburg talked about the ERA deadline when she testified before Congress about the deadline extension in 1978 as being very similar in a legal sense to a statute of limitations. Deadlines and statutes of limitations are part of the rules that are set up by the people, often in our system, men, who write the rules by which we proceed for legal change and even to make legal claims, like claims of equal pay. And so the idea is that we have these rules. You have to do certain things by a certain date. 3 strikes and you're out. There are only 9 innings. And everyone knows these rules and knows that they have to act within them. And so they should accept that if they don't follow the rules or if they get things done not within the timeframes provided, we have some understanding in our legal system that everyone should accept the outcomes of those rules. But what we have to understand is that the rule that we have in our Constitution, which is at Article 5 for constitutional change, creates something that's known throughout the world as one of the most unamendable constitutions. It requires 2/3 of both houses of Congress and 3/4 of the states. And throughout the 20th century, since the Prohibition Amendment, because Congress has power under Article 5 to designate the mode of ratification, Congress has understood that power, and judges have blessed that power as one including procedural details like deadlines, which function like statutes of limitations. And one of the most famous recent opinions written by Justice Ruth Bader Ginsburg was in the Lilly Ledbetter case, unfortunately a dissenting opinion. But the dissenting opinion really brought attention to the idea that when we talk about people who are disempowered or unequal in the workplace, the rules around time may not necessarily work towards justice. So if you have statutes of limitations that have a very rigid understanding of which paychecks count and how to count the days from a paycheck, that those rules are written in a way that actually disadvantages people who are outside of the power circle of information, right? And similarly, I think Article 5 of the US Constitution makes it extremely difficult for people who lack access to power to actually seek constitutional change that empowers them. Specifically, if you think about suffrage, women had to get the right to vote without the right to vote. So the people who were voting within Congress and the state legislatures to propose and ratify a constitutional amendment were elected by people who couldn't vote. So women had no say. And so that's a fundamental structural problem having to do with procedure and having to do with the rules of the game that I think get called into question when you look at the long history of the ERA, where women, I mean, remember how we got the Constitution. We did not get the Constitution by men playing by the rules of the game. They had a revolution. They had guns. They killed people. And then when they were unhappy with the Articles of Confederation, they said, let's not follow the rules in the Articles of Confederation. Let's just write a new constitution, right? And so we have to understand that this is a document that was actually made not following the existing rules, but the ways in which women have struggled for suffrage and for the ERA have always been, we follow the rule that's in here, right? And in following the rule now, one of the roadblocks that we're facing has to do with what the status of the 7-year deadline is in light of the very complex and rich history of Article 5 as it's been interpreted by the federal judiciary, also mostly men. I read the other day that we've had more Supreme Court justices named John ×2 than we've had total women on the Supreme Court ever historically. In any case, I just want to sort of frame that, this understanding of time and the rules of the game and the rules of constitutional change, how it's historically disadvantaged women. Because as I think I don't need to give the background to this group. I think we have a lot of experts on the recent history of the ERA. So I'm not going to go into that other than that I think, and I'm sure that most people in this group know that the House voted on Wednesday to lift the deadline. And I think we all also know that if the Senate takes it up, there will be some challenges because of the filibuster. Although many people believe that there is certainly a majority that would vote to remove the deadline. And if the Senate also votes to remove the deadline, then it would seem that the ERA can be added to the Constitution at that point. And if it is added to the Constitution at that point, I don't think that'll be the end of the fight because the states that have been suing or rather intervening in existing litigation, they also brought their own litigation, which they voluntarily dismissed. But the opponents of the ERA and the opponents of the deadline removal will argue that Congress does not have power to retroactively remove a deadline, and therefore the deadline removal legislation, even if it's passed by both houses this session, they'll argue that that's illegal, null and void, unconstitutional. They were arguing that on the floor on Wednesday. And therefore, the ERA is not part of the Constitution. And they'll argue that in various forms of litigation that they might be able to bring. They might also argue, or I'm sure they will also argue in other litigation that they will bring, that even if Congress does have power to remove the deadline, we still don't have a total of 38 ratifications because 5 states rescinded their ratification at various points throughout the 1970s. And I want to point out that this is actually a very serious constitutional argument on which experts, even experts who are sympathetic to feminism and the project of the ERA, disagree. And so I think we do need to spend some time really thinking about, are they right? The Constitution does not provide a clear answer to this question. And so then you could ask constitutional lawyers, what happens when the Constitution does not provide a clear answer? Well, somebody has to decide. And part of the fight about the ERA is who decides. Does Congress decide? Does the president or the archivist, who is part of the executive branch and answering to the president, decide? Or does the judiciary decide, lower federal court judges, and then eventually the Supreme Court? Who decides whether rescissions are valid and whether the deadline can be changed or extended? And history actually provides some hints and precedents about this. We don't have a case that really addresses this, but Congress declared the 14th Amendment ratified in 1868, even though 2 states had rescinded. But Congress counted those rescinding states as ratified states, and nobody has ever questioned that. Or actually, there were some people who tried to question that around the time that Brown versus Board of Education was decided. But I think many Americans fully accept the legitimacy of the 14th Amendment. And furthermore, many Americans believe that the 14th Amendment is one of the most important pieces of constitutional text that we have because it guarantees equal protection of the laws. So with that said, my understanding is that it really is up to Congress to decide. The president is not mentioned in Article 5. The judiciary is not mentioned in Article 5. So it's really for Congress to decide. We made an initial calculation about the right amount of time. We can change that time frame. And rescissions, we don't know. The text doesn't say anything about rescissions. But of course, a lot of things that the text doesn't talk about are allowed. Sometimes they're not allowed. Who decides? Sometimes we say judges should decide. In this case, we have the historical precedent that Congress decided and decided in a manner that was necessary for the nation to move forward towards equality. But the other thing I want to point to, thinking about the lessons of the 14th Amendment, is on this question that I think Jerry raised as we got started: what difference will the ERA make? What will it do as law? And I want to remind everyone that the ERA is stated at a level of generality. It has a lot of words about which many Americans disagree what it means. So specifically, equality, what does that mean? People have great disagreements about that. Rights, another word, not clear what it means. Even the words on account of sex, right? For some people, for much of the ERA's history, from the 1920s to the 70s, people believed that on account of sex meant equality between men and women. And today, there are larger questions about equality of all genders, which include more than just men and women, gender nonconforming people, LGBTQ, and so forth. So these are all words that have to be interpreted. And one thing I want to point you to is the fact that we got the 14th Amendment in 1868. It said equal protection of the laws. And about 30 years later, the Supreme Court said separate but equal. The Supreme Court said that you could have racial segregation in transportation and other institutions, compatible with equal protection of the laws based on this idea of separate but equal. And it wasn't until almost 100 years later, 1954, Brown versus Board of Education, that equal protection of the laws meant no more racial segregation. And I think everyone knows this story, but I tell you the story because this is another way in which once you get the ERA published in here, that's only the beginning. It's not the end of the fight for gender justice, because equality of rights to some people could mean unisex bathrooms, or women have to get drafted, or, you know, it could mean all these things. And if you want it to mean your vision of gender justice, if you want it to mean pregnant women are treated fairly, if you want it to mean that in government jobs, equal pay means something more robust than what it's already meant in the cases that have been decided, that's something that it's an act, not a state, as John Lewis always said. Democracy is an act, not a state. So once you get the words in the book, it isn't over. The meaning of those words have to be made and argued sometimes to judges, but also more importantly to your legislators. And so there, it's not, and it's also not just a matter of getting it done and making the arguments. It's really important because the techniques that judges use to understand the meaning of these words, abstract words like equality, sometimes they are textualists and they look in the dictionary and they try to think about the ordinary meaning of equality and rights. But another very important part of how judges interpret is by looking at legislative purpose and looking at the public meaning of the framers. And a lot of scholars nowadays think about social movement history as also creating public meaning. So it's not just getting it done, but creating a clear legislative history and record, the floor debates. And that's why I wrote the book. I went back and looked at the legislative history and narrated it because I wanted to find the through line from 1923 up all the way up until 2020 about why people who wanted the ERA argued in favor of it. And I'll end by just pointing to some of the things. I mean, one of the biggest arguments against the ERA right now is that it's not necessary because we have the 14th Amendment. And the 14th Amendment, and that was the prime, well, in 1972, when the ERA was adopted by Congress, the 14th Amendment was not interpreted in a manner that addressed sex discrimination. But because of the hard work that Justice Ruth Bader Ginsburg did as a lawyer throughout the 1970s, the meaning of the 14th Amendment changed radically from 1972 to 1996 with the VMI decision. And so from 1972 to 1996, the ERA sort of became part of equal protection law. So it didn't get put into the Constitution, but all of the ideas, or actually some of the ideas embodied in the ERA movement became part of the law of the 14th Amendment through Supreme Court decisions. So, but not all of it. That is, there was a very strong argument that the disadvantages women faced because of motherhood, because they were mothers or mothers-to-be, were part of the social inequalities that they wanted the ERA to address. And many of the framers of the ERA, including Shirley Chisholm, the first African-American woman elected to Congress, Patsy Mink, the first Asian-American woman elected to Congress, they were working on childcare legislation because they wrote in other writings that if you didn't have childcare, it was going to be very hard to have equal opportunity in the workplace for many American women, right? So there was a comprehensive vision. And the other part of that comprehensive vision was that they didn't think that judges were going to solve all the problems because judges basically have a limited set of tools. They could strike things down, but they can't actually write new policies. So they saw the ERA as empowering Congress, that's in Section 2. They thought that the 2-year delay in effective date of the ERA was the time for Congress and state legislatures to write new laws and real public policies to not just get rid of the things that overtly discriminated against women, but to write the policies that you needed to address the practices that were discriminatory in effect even if not intended to be, and even if there was no formal distinction made between men and women in the law. And this is extremely important today because so much of the progress that was made under the 14th Amendment was progress in the courts, judges striking down laws that overtly discriminated against women. But we didn't really get a similar development legislatively, nor did we get a constitutional foundation. Specifically, if very often a lot of laws that are gender equality promoting, including one provision of the Violence Against Women Act that was enacted in 1994, they get struck down by courts actually because someone says it violates federalism principles. And the way they say that is by saying Congress doesn't have power under the Commerce Clause. Congress doesn't have power under its 14th Amendment, Section 5. And there is a very intricate jurisprudence that limits Congress's power to do robust gender equality policy under the 14th Amendment, Section 5. And now it's very interesting. Just a few days ago, some attorneys general, mostly Republican attorneys general, wrote a letter to Janet Yellen, Treasury Secretary, suggesting that certain provisions of the American Rescue Plan were unconstitutional because they exceeded Congress's spending power. The spending power is the basis of Title IX and other legislation that is important for nationally addressing very complex dynamics that produce gender inequality. And there's ample evidence now that we are in a female recession because of the economic effects of COVID-19. We are back to 1988 in terms of women's participation in the workforce. If we want to take less than 30 years to get back to where we were, we're going to need some aggressive interventions in the context of public policy. And those aggressive interventions are going to be attacked if the commerce power, 14th Amendment, Section 5, and the spending power are read in the limited ways in which the current sitting federal judiciary are reading them. Creates a real problem, though, because these are the judges who will be interpreting the ERA that you all are working so hard to have added to the Constitution. So if you want the judges to read it in a particular way, it's very important for specific understandings. We want the ERA to overrule these cases. We want the ERA to function in this way. It has to be part of the legislative history. It has to be part of floor debates. It has to be part of hearings in Congress. And that's why I've always been in favor of having more hearings rather than fewer hearings. Even if it slows things down, I think you want the ERA that you're fighting for, not the ERA that someone else is going to take and interpret to your disadvantage. So I'll just end there, and I'm happy to take additional questions.
Thank you so much. You can see why we turn to Julie when we have legal questions. So Julie, could you stay on for questions? Because we do have Senator Spearman on, and we thought we'd have her come in here, and then are you able to stay with the program for a little bit?
Oh, of course, yeah.
Oh,
I'll
good.
stay
Okay.
for yeah.
Thank you so much. So I do believe Senator Spearman has joined us. There you are, Senator. First of all, condolences about your brother, and thank you for taking time away from, I know, his family time right now. We did have Jeanette come on and kind of give us a little reminder about this being the 4th anniversary of Nevada ratifying, and we just wanted to say hi to you and hear your thoughts on this anniversary. Thank you for joining us.
Thank you, and thank you all for your support. This was not expected, so it's like sitting down to eat dinner and a train rolls through your living room, and you're just trying to pick up the pieces. So, so here are my thoughts, and I think what Julie just said, if we pull that apart, the judges are going to be, the Supreme Court judges are going to be, I think she used the word textualist. Here's the problem with the judges, any judge for that matter, trying to figure this out, because they start from a false premise. They start from a false premise that it's already there, it's already done, and it's not already done. They start from a false premise because the first, when the Constitution was written, only rich white men really had any rights. Certainly not my ancestors. Many of you on the call, certainly not your ancestors. And so to go back and say what was the framers' intent really starts from a false place, because they could not have imagined women standing up for themselves and demanding their rights. I think that when people say we don't need it, we already have it. I think what they're doing is they're trying to divert attention away from the fact that if we already had it, the Lilly Ledbetter Act would not have been necessary. Would not have been necessary. If we already had it, someone who is a world-class athlete, a swimmer, who raped somebody who had passed out would not have, been released. If we already had it, the sheriff in Atlanta who said the shooter just had a bad day, and I was ready to rip my radio out of my truck. The shooter didn't have a bad day. The people he killed and their family members had a bad day. But it's always a matter of trying to minimize whatever is attached to females, whatever is attached to women. You always minimize it. Well, sexual harassment, it's just boys being boys. Come on, you just don't. And so it's always trying to minimize. And that's why I say this. They can't come to the right conclusion because they're always going to look at it through the lens of a white man. And they have no idea what this current configuration or lack of equality is for women. And I'll say again what I said when I testified at Congress. For those who have been born in privilege, they have no idea what we're talking about. They can't fathom it. It's like going back in time and carrying a microwave with you and trying to explain how it operates to somebody in the year 1776, because you didn't have the word microwave didn't even exist then. The word microwave, I don't think existed 35 years ago. So they have to start from the place, and I'm sure that they probably won't, but they have to start through at the place looking through our lens. You have to look through our lens. I hate it when people tell me as an African-American woman, well, you shouldn't be so sensitive about race. Really? Really? Okay. How about you step in my skin for about 5 minutes and walk into a store? Then you come back and we have this conversation, because you don't know what it feels like, and they don't know what it feels like to be a woman and to be minimized constantly. And the implicit bias that is always there. We always have to prove that we are worthy and that we should be wherever it is we are. Even in elected office, we always have to prove that. And so whenever people say, well, we don't really need it, we have it. And I'm like, okay, no, we don't. And Ms. Lilly, I want to thank you. We used the Lilly Ledbetter Act, and that's what we modeled our Equal Pay Act, our equal pay legislation here in Nevada. States are doing that one by one, and it's a patchwork, it's a quilt. And if we already had it, then we would not need to do it. And the other thing about already having something, unless it's in the Constitution, one legislature cannot bind succeeding legislatures. And so whatever is in statute today can be taken out tomorrow. And so, I tell them, miss me on that we don't need it. Okay? Miss me on that you all don't know what you're talking about. Miss me on that, oh, well, it's just the women again. Miss me on all of that inequality talk, and you want me to bring out, the pom-poms and no. We're not doing that. We're not doing that this time. Okay. Now you might have been able to shut us down 30 years ago. You might have been able to shut us down to a certain extent 50 years ago, 100 years ago. But guess what? This is a new day, and we are persistent. And this time we will not give up until the 28th Amendment is in the Constitution. We will not do it. And so y'all just need to get it in your head. We ain't going nowhere. All right? We ain't going nowhere. Have somebody bring you lunch and dinner, because we ain't going nowhere. We ain't going nowhere. All right? We are here, and we're not leaving. We're not putting the gauntlet down until the 28th Amendment is law. So miss me on we don't need it, okay?
Thank you so much. That we need that inspiration. It's been a good week, but we know we have so much more to do, and I appreciate you taking time away from your family to join us. So always inspirational, of course.
Thank you.
And I hope you can hang out, because Zoe's going to introduce Lily, and we're so excited about that. Zoe, are you there?
I am here, and I just
don't see your
muted,
picture.
God forbid. As I tell people on Zoom meetings, my mother prayed for a mute button, but there never was one for me. So Eva, are you going to show a couple photographs here?
Yes, I will.
Oh, great. Yeah, I think we have 3. So while we're getting those a few photographs up, I want to tell you that in January of 2020, I got a call. Actually, 2019, I'm sorry, January 2019, I got a call from 2 very disturbed and crazy twins named the Lane twins. They told me they were going to make a movie with Lily Tomlin, Jane Fonda, and Dolly Parton, and they wanted me to be in the movie. And I thought, well, damn, it's about time. Actually, it was a documentary called Still Working 9 to 5. And they had come and filmed me speaking at the Women's March in Los Angeles, and they are rascals. And so they wanted us to be filmed in Virginia in January 2020. And they called me at Christmas. I don't think Lily even knows this. They called me at Christmas. I don't know where those pictures are, Eva, but I'm looking for them.
So I've got some pictures, but I thought they were for Lily. I got one from you.
No, there were 3 of us in Virginia.
Yeah, it's the one.
Yeah,
from
okay.
Lily. It's the ones from Lily, Eva.
Okay, all right.
Thank you.
That's why I was hesitating.
No, please, if you can put them
There
up.
you go. There you go.
I'm going to go fast. Yeah, so they told me that they had a Christmas present for me, that they had invited Lilly Ledbetter to meet us in Virginia. And I'm telling you, as much as I can open up my heart right at this moment, I started to cry. And they said, Zoe, what are you crying about? And I said, you just don't understand. This is the Elvis Presley of the women's movement. This is the most important figure in my life. This is a woman who went to the Supreme Court, and when the Supreme Court didn't say yes, she went across the street. And I had the privilege, and my head was swimming. She doesn't know that either. You can go to the next picture. I got to sit next to her at dinner. I barely remember what in the blue blazes we talked about, but I am so moved to know you, to love you, and to present to the people today, to hear you talk. This is a woman who made history for all of us. And with that, I really want to turn the floor over. And you can see, by the way, we were in the Lucy Burns Museum there, but I have a feeling Lily might want to tell you about that. But it was quite a time we had. And I'm just so proud to introduce her to all of you. This is the most wonderful woman, Lilly Ledbetter.
Can we unmute you, Lily? You're still on mute.
Lily, hit the unmute button.
There
I got
you
it.
go.
I got it. Good. Thank you. Thank you. Thank you. Yeah, I got to meet Zoe and Jerry and Jerry's husband, and we had a great time up there with those two crazy, wonderful guys. And it was such an education to get to meet Zoe and knowing her history, and Jerry, all that she's done for ERA. And I was an ERA girl way back in the early days of my fight, but the senator was exactly right. Had we had ERA, my case never would have been, and I would have gotten my equal pay, because equal pay law was passed in 1963, Title VII in 1964. And I would have had equal pay because that's what the law said. But the problem with laws is they must be enforced. And no one ever made sure that the companies and employers were paying people according to the law, equally according to what it should be. And I'm not the only one. I learned that I'm just the tip of the iceberg in this country of the people that's gotten unequal pay for equal work. But when I learned that, I just couldn't let it go, because I had worked for a corporation for 19 years, and they had government contracts from the day I walked in until the day I left. And I thought surely the government was holding them accountable and for documentation and proof that they were adhering to the federal laws, equal pay for equal work. But I found out they did not. There was no laws that enforced that. They could get those contracts if they could sell the prospective company or they own it, and that's all they had to do. But that was why, and also I worked for a corporation that said if you discuss your pay, you will not have a job. So no one ever discussed their pay. They gave out raises in the management area randomly. I never knew when someone else got a raise. They didn't know when I got one. None of us knew exactly what anyone was getting. But it was an eye-opener at my trial when that board was put up, and all the 16 people of us that worked in the same department, the variances in our pay. But I've learned through an anonymous note. But I do want to share with you two things about this group tonight that makes me very proud to be here, even over knowing Jerry and Zoe. But the ERA, I went to New York in my early days before the Ledbetter bill, I think, ever passed. And Congressman Carolyn Maloney put me up in her home. I stayed in her home. I think I stayed a couple of nights. I toured around New York raising money to help fund the fight for ERA, because it does take money to fight, as you well know. And I stayed up there, and it was real funny. The first lady that was supposed to escort me to all the stops and to the courthouse, she got me on the wrong train. We went the wrong direction. So that didn't work out too nice. But we finally found our way, and we had left early. So we made it and got there in time for me to talk in the courthouse. And that was good. So that got a lot of attention. Went to another place where there were a lot of Republicans and Democrat women, mostly Republicans though. And they got the conversation going, because like you heard earlier, we need support from Republicans and Democrats, and we can do it. It can be done, because the Ledbetter bill was sponsored and co-sponsored by Republicans and Democrats, and it became law by both parties. But also now, when I went to Washington the first time to do a press conference and to testify before the House, Congressman George Miller's committee, NOW was there. I met all of those people and worked with them for many years. In every rally, I've got photos in my den right now hanging where I was in rally after rally after rally in different locations, different cities, and those NOW signs was riding back on me. And they helped get the Ledbetter bill passed. But early on, the NOW group was having their convention that year, their national convention in Washington, D.C. They invited me to speak. I wasn't the main speaker. It was just late afternoon, I think, maybe after a luncheon. But I spoke, and I wasn't very good in those days because I had not given that many speeches on my subject even. I'd mostly been testifying. But later on, about 15 years later, I run into one of those NOW women someplace, and she heard me speak again. And she said, boy, you really have improved. I said, well, I've had a lot of practice. And I've seen that shown a few times, and she's right. I've really improved. But I want to share just a little bit about my case and why it's so critical. Your first speaker hit on a lot of the main points. In my case, I worked there for Goodyear Tire and Rubber in a management position for 19 years. Someone gave me an anonymous tip, a piece of paper telling me how much less I made than the men. And the first thing I thought about was all the struggles in my family, trying to make ends meet, pay the mortgages, make the car payments, send kids to school, keep them well, pay the dentist. That was the first thing. The second thing I thought about my overtime, because in the position I had, we worked overtime. We were required. And also I might work 2 months straight, 12-hour shifts. That's a lot of overtime. That was a lot of money I had lost. Then I thought about my retirement. It was based on my earnings, my 401k, and today my Social Security all. I couldn't let it go. I thought about it all night. I was working a night shift, 12 hours. I wanted to take my personal belongings and go home. I couldn't afford to. I couldn't quit. I still had that mortgage and had 2 kids in college. I couldn't go home, not until my shift was over. But I told my husband the next morning, I've got to file a charge with Equal Employment Commission. And I'll warn you now, if I start, I'm in it for a long time, probably 8 years. It actually took 9. I filed that charge in 98. Equal Employment was backed up, and they advised me that I had one of the best cases they'd ever seen. Get my own attorney, I'd probably get to trial faster. That was very difficult too. We finally got to trial. I got the attorney in 99. We got to trial in 2003. After a week in the courtroom with people testifying on my behalf and against me, the jury came back on Friday afternoon with a verdict of $3.8 million in my favor. Now, I had been told to keep a straight face, not make any outward appearances, but I sure didn't want to shout because the jury got it. They got it. They understood it. And that large amount was to compensate me for all of my lost wages, lost overtime, and my back pay and my future retirements. That's what that was about. They got it. But what happened, of course, Goodyear appealed. It went to 11th Circuit. They denied it. Then we appealed to the Supreme Court, and we went to the Supreme Court in November of 2006. I got to go to Washington, and I sat in the Supreme Court and heard my case presented. I had left my husband at home. He just had the left side of his face removed with cancer and skin grafted from his right leg. But he supported me, and he said, you must go. It's important you're there. So I did go to Washington. My daughter traveled with me, and I've heard the case. We waited from November until May of 2007. Justice Alito wrote the opinion. He said, definitely I was discriminated against, but my problem, I waited too long. But the lower court in Birmingham, Alabama, the federal court, one of the federal judges had combined 2 of my cases together. I actually had 4. I lost the age discrimination case, and I really wanted to win that one because to me, age is very important, and that's extremely difficult to prove too. And it is, and I lost that one. But I won the equal pay. And the judge reduced the amount in the lower federal court immediately because Congress had put that cap on in 1991. But Alito said I should have filed my case the first discriminatory paycheck I got. I didn't know. I didn't have a way to find out. If I'd asked, I'd lost my job. And when I did ask later, they wouldn't tell me. They kept putting me off. They wouldn't tell me. And that wasn't right. But he said I should have filed my charge the first check. If that's the case, that means that a new employee gets a job, they've got 6 months that they can file a charge if they're being discriminated against. And Helen's, most people wouldn't know that. You're not thinking about on a new job, am I being discriminated against? That was crazy. And Justice Ruth Bader Ginsburg read her dissent loud and clear. She said, these people do not know what it's like in the real world. They do not understand or they don't care. She said, and people do not stand around discussing their pay, even if you knew they were making a little less. Now, people in middle income America like Lilly Ledbetter and many other people, we can't afford to hire an attorney that can hold out with us for 9 years and back us up with all those depositions and investigations and testifying fees. All those expenses are very run up a big bill. But the law firm that took my case was doing it on a contingent basis, which meant they would have gotten 50% of whatever I got. But at that time in my life, I just wanted what was right. So Justice Ginsburg said in her dissent, too, she said it's up to Congress to change this grave injustice back. She said, you must change it back. And it was critical that it be changed. And she challenged Congress that it had to be changed. And they took it up almost immediately. And Congressman George Miller called me and invited me to Washington to testify. I testified twice in the House, twice in the Senate. When I testified in the Senate before Ted Kennedy's committee, his staff had put together 2 charts on Chief Justice Roberts and 2 on Alito because those 2 people had just been added to the Supreme Court. Chief Justice Roberts had just taken over. And what happened, he said in his confirmation he would call balls and strikes and he would adhere to previous rulings. Well, all the cases, like the Ledbetter case, had been ruled, it would have been ruled in my favor. The Bazemore case was one of the most recent ones compared to mine because it had always been interpreted based on paycheck accrual rule. And laws are made, and a lot of times they're not black or white. They're a little bit gray, and there's an interpretation, and it's called common sense. And the judges in the past have been adhering to that and following the law. But in my case, with that little tiny technicality, they ruled against me. But that was okay, really. I got the call in May, and when I got that call, they told me, they said, don't worry about the media. It's what my attorneys told me. We'll handle it. I didn't worry about the media, but when NBC called, I invited them into my home. CNN called the next day, I invited them in. Norman Lear sent his crew in with American Way, and we made a whole ton of videos to run on YouTube. Politicians started calling, wanting some help. And I wanted to help because we needed more Republicans and more Democrats. I walked those halls of Congress in the next months, 18 months, while my husband was doing radiation and chemo in Alabama for his cancer. But he always supported me, and I left him at home in good hands. And I traveled to Washington and walked the halls to get support from Republicans and Democrats. A lot of those young assistants in Washington were young men lawyers, and they would have tears run out their eyes and down their cheeks talking about their mothers working 2 jobs to send them to law school. They knew exactly what I was talking about. And your senator a while ago, she knows too. She knows exactly. That's what's wrong with some of these politicians. They do not understand what it's like. But you had a politician from Nevada that I dearly loved, and that was Harry Reid. He gave me a hard time, and he fussed at me. And in the very early days, I'll share a few little tidbits along for you. When I'd go to Washington, I couldn't get the real congressmen or I couldn't get the real senators. It had to be their assistants because I did have appointments because I hit one right after the other. I had to make my time count because somebody in Washington was buying my tickets and they was putting me in a hotel because I couldn't afford that to get that job done. They called me the poster child for unequal pay. I go into Harry Reid's office in the last go around and with a big group, somebody from NOW, AARP, and it was just everybody was in there. All the big organizations was represented. He'd look at me, Harry would, and he'd say, "Hey, what do you want now?" And but I thought the world of him, and he was so smart and so knowledgeable. And Ellie Smil from the Feminist Majority and I came to Nevada, and we campaigned for Harry the last go around in Las Vegas and on up to Reno. And we had a great and wonderful time. And we really thought the world of Harry. Harry done a good job for people in Washington, and I can't say enough about him. And he understood what it was like. But it's really tough that women are struggling today, and they're locked into a situation they can't. It's locked in where they can't really do anything about it, because I've asked women when they've told me that they knew they was making $80,000 for a job, the men was getting 125. I said, why didn't you complain? Why didn't you go to equal employment? She said, if I had, I would have been back being a secretary or unemployed. And she said, I made the money that I got and I managed it well and was able to raise my daughter. She was a single mother. And that story after story. The lady in Chicago told me that when she asked about her equal pay, 2 months later, they gave her a pink slip. She didn't work there anymore. That's why women cannot get ahead. And that's why we need ERA. We need equal rights for the women. And there'll be more. If it's I think if it's in the Constitution, it'll carry more weight for things to get done and laws to be adhered to. If a lot, your senator was right about the states passing laws, equal pay laws. I'll be testifying week after next in Delaware again for the people up there, because about equal pay and women's rights and men and women being, and they should not be penalized. A job is a job, and if the woman is qualified and has the qualifications and experience to bring with it, she should get it, and the money should go with it. They shouldn't worry about, is she going to have a child? Does she have a child? Is that child going to get sick? They should not enter those things in those decisions. It's a job, and if the woman says she wants it and she can do it, accept her. Put her in the job and give her the money. But I hope to see ERA passed, and I hope to see the other bill in Washington that's being worked on right now too, because had paycheck fairness been the law in my day, I wouldn't be here either. I could have found out, and I would have found out. I didn't work 12-hour shifts 7 nights a week because I liked it and enjoyed it. I did it because I had to support my family and I had a future. And it's not right. And there are so many women in this country today that are living on just bare necessities, can't feed themselves. They move into their children's homes because they're outliving their spouses on average by 10 years, and they don't have enough income. And some of them have worked for 30 and 35 years in jobs that they should have been paid equally and fairly. I'm really dedicated to trying to work and get people equal pay for equal work, because that's very important. But no one ever enforced it. And they don't do too good a job today. I think they'll get back on it in Washington now. And President Obama signed a bill in 2014 that required April 2014, that April 14. I'll get it right in a minute. No, don't hold me to that. But anyway, he signed that bill that would require people that got contracts. And that's another item that states do. They're taking care of it themselves. The states will, New Mexico is the first one I came in contact with that said to their contractors in that state, you will not have them if you do not adhere to federal and state laws. And they were being checked. And that's happened in most states. The states can control the laws better than the national. It sort of gets out of hand. So, but ERA, I'm with you. And I appreciate you folks allowing me to come with you tonight. It's a pleasure, and it's real good knowing Jerry and Zoe. Are we going to open for questions or anything?
Yes, we will. We're so happy to have you here. I feel like I've given a Women's History Month gift, just Zoe and I having you with us, and Julie with us. It's a gift to our members of our different groups. But I see so many people in the chat, Lily, talking about how much you helped women's lives, that they're just so grateful. I mean, the length of time you took to get this done. Just quickly, I had an equal pay situation at my work. I didn't know I was not being paid equally to the two other men in my sales job, and someone told me, and it took me a few years. It was actually until I was at a equal pay protest with Nevada Now, when they actually kind of said we better do something or she's going to sue us. But I had a lot of people say what you said, that, why don't you do something? I was raising a single child. I was single with a child and a mortgage, and people don't, and look at how, and I listen to you and I think what strength and what that took to do when you do have to, you have to make a living. That's why you're working. And I'm just so grateful to what you did and what you do for women. It's amazing. So thank you so much. And Julie too. And we thought we would open it up to some questions. Eva usually helps me with the questions if we see. Zoe, do you have any questions to start off, or?
Well, I certainly want to say that I'd pay $1 million if I had $1 million to hear Miss Ledbetter say, we need the ERA. There's nothing like it when you hear it with an Alabama accent there.
That's right.
Amen to you. I'm still in shock that I know you. And I'm just so pleased. I see that photograph, which I know every woman here can picture. That photograph with all the ladies with their red jackets standing around the table as President Obama was signing the Lilly Ledbetter Fair Pay Act. And, every single one of us, our lives are better because of you. And it's not lost on me at all. So I'm just so proud that you said yes. And I can't wait to sit next to you at dinner again. Thank you.
Absolutely. Thank you.
So, some questions. Go ahead, Jerry.
I didn't know if Eva had noticed some questions in there. I know Senator Spearman's still on, and she has been working on her pay equity bill that we passed last session. Any words on the one we're working on now, Senator Spearman?
Yes, ma'am.
Lily could give us some advice.
Wherever you are, if your state does not have a equal pay bill, then bother your legislators until you get one.
That's right.
Bother your legislators. Just make a nuisance of yourself until you get one. We took everything in the Lilly Ledbetter Act, but what we did in Nevada was whatever the amount was that was owed, it would be times whatever the highest interest rate was in the state on the date that the case was settled. So if they said you got $50,000 and the interest rate was at 4%, that's what it would be times by. And we did it that way because it's not just the pay that you lose, but it's your FICA that you lose. It's your 401k. It's what you lose in vacation time. It's what you lose because you should have gotten a promotion. And so all of those things, and it was our intention to make sure that women were made whole. And the other thing that we did, and we didn't broadcast it because everybody got hung up on the fines. If it happens the first time, it's 5,000. Second time, it's 10,000. I think it's third time, it's 15,000. Everybody was hung up on that because initially it started off at 15,000, would go up to 50. And they were all hung up on that. And they did not notice the other part of the bill said every time the person or persons that are being paid more than you are, every time they get a paycheck, your clock starts over.
Uh-huh.
So it's not, this 6 months, every time that person or persons gets another paycheck, the clock starts over. I have two bills this time that I think we'll get it across the finish line, but I'm going to ask for help right now. One is Senate Bill 267. I think I put it in the chat. And what that one will do is every corporation that has business in Nevada that is on the New York Stock Exchange, every one of them will have to fill out a diversity audit every year.
I like that.
And what it will do is once the diversity audit is filled out, then it will be published. And so whatever they are doing or are not doing for women, everyone will know it. And in this day and age, one of the things that I know that corporations really want to do, and that is to protect their brand. And so if they're not doing it right now, trust me, they will be doing it after January 2022. The next one is a bill that will require diversity of women on boards of director. That is very important because that's where the decisions are made. And unless you have women, and we're talking about diversity in gender, ethnicity, gender identification, unless you have that type of diversity in the boardroom, everything that you do will be done through a white man's lens. And so I hope to get that one passed too. These are just some of the little things that I know when we get it done, it will make things a whole lot easier, even after we have the 28th Amendment, because it will be in state law. And by the way, this session, we will pass out SJR 8, which is the resolution that will put ERA in the Nevada Constitution. And so we will pass that out, and it will go to a vote of the people in 22. And we're going to need everybody to make sure you get out and vote, so we can get that in our Constitution.
Thank you. And Nevada Now is definitely behind you on that. That's our number one on our legislative list, right, Sue?
May I say one more thing?
Yes, please.
The senator's my new best friend. She may not know it, but I like her. I do. And she would like it when I do. I tell you, I couldn't let the equal pay thing go, and I don't let anything else go, ERA either. It's got to be. And when people talk to me negative about it, I said, well, and then I'll start presenting my case about, do you really want to live in a world like that when you have no say? Well, I'll ask my husband, and that really ticks me off then. So she's hit everything on the head. So you're my new best friend, Senator.
We love her too. And Professor Suk, there's a question here that says, this is from Kate Kelly, where I'm excited she's on the program today, a very famous ERA activist for those of us ERA activists. She's saying, well, Kate, do you want to speak for yourself and ask the question? Are you there?
Hey.
Hey.
I'm sorry. I'm trying to get hi, everybody.
Hi,
there you are.
Great to see you.
I'm not really camped ready here, but
well,
I thank you so much for this program. It's been incredible. The incredible women on tonight are just inspiring me and so exciting. And I just wanted to give Julia a chance to talk about, because we've talked about equal pay and we've talked about the ERA and why we need both. And I just wanted to give Julia a chance to talk about, how is it exactly? Because I know politicians often say things like, well, if we get the ERA, we'll get equal pay. And it's like, okay, it's not automatic. Like nothing with the ERA is going to be automatic, although it is a good line. And I think we should definitely use it. So I'm just wondering, because you're so brilliant, Julia, if you could just talk about why you think the ERA and equal pay are connected.
I think more people would get equal pay if we had ERA than they have in the past, because I like to tell groups the law, equal pay law that John F. Kennedy signed was sort of like my driving in Alabama. If I'm off on a trip, I get back to the airport and get in my car, I want to speed unless I know that trooper is out on I-20. And I can't afford that ticket, so I don't speed. There was some control over my driving, but there was never any control over equal pay law. He thought it would he'd sign that law and it'd just be great. Everybody start getting their equal pay, but it didn't work that way. ERA would force it to be more equality. It would help, because then men and women would, and a lot of I think even the women going into the military and getting promotions and going all the way up to combat, they wouldn't have had to fight so hard to get those positions had we had ERA. And it's hard to believe, and when you explain ERA, when I explain it to people in Alabama, when they tell me, well, I don't know anything about that, and I explain it, well, that makes sense. They don't understand why we didn't have it then. And so it's, they've kept it out of the state. We've not passed it. So, but we do have one small little equal pay law in Alabama, but I don't know if it's been adhered to. But one thing that the Ledbetter bill did bring, it brought a lot of corporations turned around, and they wanted to be known as a good, equal employer for real. And they changed their policies and procedures. And they have implemented a lot of programs. And so I tell young people, search those out, because it is critical. Women are outliving the men, and we got to have equal pay in order to survive. We just need what we are earning. We're not asking for a gift. It's what we're entitled to. And it gets your retirements. It gets everything for the rest of your life. It's how you live today. And if you don't get your rightful pay up front, raises are generally percentages, and everything in the future is lost, because you can't make it up. Once it's gone, it's gone. I went as far as I could in the Supreme Court, and I lost. I didn't get a penny. I didn't get a dime. My attorneys has $500,000 in my case, and they never got a dime. We both lost. But in the long run, we won. And that Ledbetter bill was passed in 18 months. And it was passed because we all got in it. Now, everybody was involved in Washington and across the United States, marching and calling to get the bill passed and getting votes. So that's one thing that I'm so proud of, because it was sponsored by both parties. It's not one party or the other. It's a fundamental American right, just like ERA. It's a fundamental American right. We have ERA in this country. Both men and women or anybody else should be the same. But thank you for all you do. Thank you.
Julie, you want to tell us about the legal piece? How are we going to move this forward so we get equal pay?
So I don't think that the connection between the Equal Rights Amendment and equal pay practices is automatic, because the Equal Rights Amendment just says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And the way most lawyers understand that language is that it only binds, and it's consistent with the way we understand constitutional rights in this country in general at the federal level. It only binds the federal government and the state government. So it will only outlaw unequal pay for public employees at the state level, teachers, civil servants, and at the federal level. And so if Walmart is underpaying you, that doesn't directly violate the ERA as currently worded. So that's one issue. But it does say equality of rights under the law shall not be denied or abridged, right? Now, what does it mean to abridge equality of rights? If the state knows that there is a massive displacement of women workers because of what happened with the pandemic, if the government knows that and does not do anything about it, is that an ERA violation? Now, under the way that most constitutional law scholars and lawyers think, it's not a constitutional problem because the way we think in this country about constitutional rights is generally very negative, meaning unless the government is actively taking away your money, it's not a constitutional problem. The government sitting on its hands while all kinds of inequality is going on, generally not thought to be in this country a constitutional problem. But I want to invite you to imagine an alternative universe in which in other countries you have constitutional rights that bind corporations in other countries. So I'll give you an example. In France, they passed an amendment a few years ago in 2008 that said that the law shall promote equal access by men and women. They already had an ERA back from after World War II, but they then passed an amendment in 2008 saying that the government shall promote equal access by men and women to the electoral mandate and all positions of social and professional responsibility. And after that, the legislature just got really hard at work on really tackling equal pay. And one of the very interesting and innovative laws that they passed in France just a couple years ago is a law that requires companies to do an audit, an equal pay audit. And so they have to measure things like how many people got promotions in your workplace after they came back from a maternity leave. And they get a certain score also by comparing the pay that men receive in the company versus the pay that women receive. They analyze jobs. So it's a comprehensive equal pay audit, and every company gets a score that they have to publish on their website. If their score falls below a certain level, like if they fail, they get 3 years to correct it. So they have to start, paying women more. They have to do what it takes to correct it and to get a better score. And if they don't get a better score, they get fined. And so that's a real system. And note how this system works. It is not the Lilly Ledbetters of the world spending 11 years litigating a case and not getting a penny in the end, right? It is not being disappointed by the courts and waiting for Congress to act after all that disappointment in the courts. One of the biggest problems with our anti-discrimination laws, including equal pay laws now, is that it puts the burden on victims to enforce the law. That is the American way. We litigate, and we have a lot of laws that also encourage that model by having lawyers working on contingency. Contingency is actually not a way in which lawyers work in most countries outside the United States. So that's our political economy of law enforcement, that we put the burden on people who have been victims to enforce the laws. Now, some people might say that's empowering because you control the litigation with your own attorney instead of depending on the government to take care of you. I take a different view. I think having a more robust governmental model in which we live in a democracy and then the government actually investigates big companies and finds them would make more sense. And I do think that having an ERA might create a tool and a catalyst by which government took a more active role in promoting gender equality. And then the last piece of it, which I think is important, is that Senator Spearman mentioned a legislative proposal in Nevada to require corporate boards to have some women on them. California passed a law like that in 2018. Guess what? It's being litigated. Conservative groups are claiming that it violates the 14th Amendment because it is, and they're also violating that it violates the California Equal Rights Amendment because it says that you have to have a woman, and that's making a sex classification. That's treating men and women differently, and therefore that's. And I think what I want to point all the activists to the real problem this causes, because the reason they're able to say that in that case is they're saying, well, for race you have strict scrutiny. And strict scrutiny means if there's a classification in the law, it's illegal. So affirmative action is not allowed under strict scrutiny. And in California, the California courts have used strict scrutiny for sex classifications as well. So the California case, there's actually a very strong argument that under existing constitutional law, it's unconstitutional. Now, it's possible that if we got a new constitutional amendment like the ERA, and this is exactly what happened in Germany and France with their more recent equality amendments, they wrote them specifically to say that affirmative efforts to overcome women's disadvantage or underrepresentation are constitutionally permitted and encouraged. And if that's what you want your ERA to mean, if you want your ERA to support a law that requires more women represented in corporations, as opposed to striking that down, it's very important that you stop talking in terms of strict scrutiny. Many activists say we need the ERA because we need strict scrutiny for sex classifications. The more you say that, the more you're killing any laws that promote women's representation and overcome women's underrepresentation, because that is the tool that is being, in the 70s it was different. In the 70s, strict scrutiny meant civil rights. But in the late 80s, lawyers started using strict scrutiny to attack affirmative action. So now if you say, we want the same level of scrutiny for sex as they have for race, which I hear a lot of ERA activists saying, it's a way of saying, please courts, take the ERA and kill off affirmative action for women. And I think it is important to be aware of how the laws have developed and how the jurisprudence has developed, because it changes the meaning of what things were said in the 70s and what they mean today.
Thank you. That was very informative. I learned something every time I hear from you. I see the Senator Spearman has a question.
Yes, ma'am. It's more of a comment.
Okay.
As Julie was speaking, it occurred to me, we have to look at this in the long game, because even after it's in the Constitution, we still have to affect hearts and minds. And so I would encourage everybody, every election that happens at the state level and the federal level, between now and the time we get the ERA into the Constitution, make sure you are voting for people who will then turn around and make sure that they write laws and pass laws that will enforce it. Because if we just focus on we got to get in the Constitution, then we will fall short. Make sure, examine everybody that is running and asking for your vote. Ask them where they stand on the ERA, and don't just say, well, yeah, I'm for it. No. I need to know what you've done in the past for that. And we have to make sure that at the state level and at the federal level, we have people in those seats that will then make sure laws are written to enforce the ERA.
Thank you. Good point.
Yes.
So Zoe, we planned on this lasting a couple hours. We're an hour and a half in, and I wondered if maybe we could take a point of personal privilege. And I know you have a story that you were telling me about at the Hollywood Now presentation the other day that I had never heard that story. And I also, before you start that, I wanted to tell everybody who hasn't already seen the success that we had on Wednesday. What do you think? So, yes? I'm waiting for your approval.
Hi. Oh, yeah. I mean,
well,
yeah.
So on Wednesday, yes. On Wednesday, the House did vote on H.J. Red 17, and it was a successful vote. And Zoe and I have been working on our project to get ERA Yes masks out to the president, the vice president, a plethora of people in the executive offices, but also to Congress and the Senate. And we weren't sure how to go about doing this. Zoe, first of all, has sewed about 800 ERA Yes masks, of which 400 were earmarked to go out. The other 400 have been sold to people and helped with our project. And then we thank people who've given us donations for our project. But probably about 400 or so, I think, right, Zoe, are going to Congress, Senate, the executive branch, and we sent some to Rachel Maddow and Joy Reid. We're trying to get the word out. And one of the problems we had, as you see, was successful, was how to get it to people with the security in the House right now and the Senate. And how are we going to get these masks in their hands and not just sit in the mailroom in DC? So we took the time to individually mail them to their home offices for Congress. And that meant that they had to get them from California or wherever they're from and bring them with them back to DC. And so imagine our excitement Wednesday when they were going in for the hearing, and in walked Carolyn Maloney with our mask on. And this is the 28th Amendment ERA Committee masks, but Zoe and I did the bulk of the work. Zoe sewed them all. I packaged them in these lovely green Mylar packages. And look, it worked. Carolyn Maloney walked in with the mask on, then it was Jackie Spear. I have the name so I would remember. Congresswoman Weston is the one wearing it, presiding over the vote. And then we had Steve Cohen.
My congressman is there. On the lower right is
Yes.
Representative Alan Lowenthal. And I also want to mention that on this call happens to be the mother of the man who told us what to do, how to mail them. Clayton Hurd's mom is on this call. Lisa
Yay.
Hurd. And it was because of her son that we sent them to all their home offices.
And it worked. And we're so
worked for Alan Lowenthal.
Thank you so much. It was a great idea. And then the gift that keeps on giving, they walked out front. There were 6 or so with, as you see in the picture, the group picture with the masks on. And then as they've been reporting on it in the New York Times and other, there's our masks. So I just had to let everybody know that this kind of a activism worked as well. So we're working on getting them to the Senate. Katie Hornung was going to take them for us, as many know, but I think we're going to, since this worked so well, we're going to mail them to the individual offices again. And then if anybody has an inside to Biden, Elisa Sales has the masks. She's trying to get him into Biden and Harris and some of the other communications people. But we just want to make sure it doesn't just go in the mail to the White House and sit in the mailroom. So we're still working on getting them to them. So I just had to let everybody know how successful we were, and it was so fun. So, and then Zoe, do you want to? I think that Eva has your picture as well. Tell us the story that you told the other night. It was so interesting.
Okay, I would like to get that screen up. I'm not an academic. I don't have a law degree. I read a lot of newspapers and I look for a story that nobody else knows. That's pretty much what I do. And I find things that are so crazy interesting. And these last couple of weeks, I've been learning a lot about the Rivington House. This house is in Lower Manhattan in an area, a neighborhood that now is actually called Hell Square. It was built in the 19th century, but at the turn of the 20th century, it was home to immigrants who were arriving from Ellis Island and of Irish descent and Jewish people. And in 1904, well, let me tell you what, obviously I would think everybody here knows that settlement houses are the beginning of social work. It's where people learned their new language, their new country, and how to get housing, how to get work. It's where they could really orient themselves to their new life in America. It was usually managed by volunteers. Lots of college students from all over the country would spend their senior year working at Rivington House. Or in one really famous case, it was the Junior League of New York. That second picture from the left is a children's classroom. In 1904, a young lady who had just made her debut to New York society and was a member of the Junior League, I say that with tongue-in-cheek, she worked there. Her name is Eleanor Roosevelt. And just 4 years later, a Quaker girl who was a senior at Swarthmore worked at Rivington House. Her name is Alice Paul. And on the far right in the upper side is what Riddington House looks like today in 1982, as the newspaper article says on the bottom right. This was a safe haven during the outbreak of the AIDS epidemic that really seriously ravaged New York in the early 80s. And Riddington House was one safe place for people who were really managing this unnamed and dread disease, where they could go. But I want to tell you a little bit about why this is so important to me. If you've read the introduction to Gerda Lerner's own autobiography, or the life of Oscar Romero, one thing that happens when people who are so privileged, they have everything, as you can only imagine, Eleanor Roosevelt's birthrights. Alice Paul was the daughter of a banker. And this is very much my own experience coming from a very privileged house, that as soon as one encounters the poor, there's a certain type of person that looks and says, what can I do? How can I help? How can I change this? And Alice Paul talks about this, that it was, in fact, her senior year at Swarthmore, working at Riddington House, when she thought that social work will never do, and that the only thing that will really make a difference in Americans' lives is equal rights under the law. And it was at that time, at the age of 21, she began working on the Equal Rights Amendment. And if you've seen my show, Tea with Alice and Me, you know that voting was really unimportant to her. It was just a stone in the mosaic, as she put it. And on the night of August 26, 1920, she moved out of headquarters, moved into a cheap apartment, started law school shortly thereafter, and got 3 law degrees, and started working on the ERA. And because I like to tie this when I tell people stories into your lives today. On the bottom right, you'll see that's Lady Gaga, who was a member of the Rivington Rebels. And that's a picture of her with the Rebels in a bar there. And it was the cover of a Beastie Boys album quite a while ago, 20 years ago or so. But when you go back and you find out what their motives are, I find that it's how I realize the roots of my own activism. And the confrontation of the people who were pre-union, the farm workers working on equal pay, is what got me started in when I was 8 years old. So anyway, when you go to New York, go to the Rivington House. That's it. Thanks so much.
Wonderful. I just love that story. And I look forward to going to New York with you.
Yes, let's have a drink in that bar. We need to help.
And Lily can come with us too.
Oh, you know it.
I'm with you.
Julie's already in New York.
The 3 of us are going to be going. By the way, Lily, you better put this on your calendar. I think the 3 of us are going to the Oscars in a year.
That's right.
All
Twins
right.
are working on their movie, 9 to 5. What is it called again, Zoe, the
It's
movie?
still working 9 to 5, and it's going to be coming out, we believe, in September, in time for it to be nominated. And I don't mind saying, because I know it's just us girls, that Dolly Parton has rewritten the opening song. And of course, if anything's going to get an Oscar, it'll be a song by Dolly Parton. So possibly we should all meet in Los Angeles a year from right now.
I'll be ready. I'll have my vaccine ready to go anytime you want to go. And
sparkling wine for everybody.
So Lily, we're getting kind of close to the end, and something that you said to me when we were talking, which, let's face it, ladies and gentlemen, having Lilly Ledbetter call you to talk about these things is just so cool. So anyway, Lily, what you mentioned was when we were at I know you feel the same way, Zoe, when we were at the prison walking around, how you were struck by that you didn't just, that it's still a year later has really stuck with you. And maybe tell people how that felt when we were walking around that prison and learn. And Zoe was giving us our tour of the suffragists, and please tell me how you felt.
Zoe was giving us more history than I knew for sure, because I thought I was really up on the suffragettes because I go around talking about the vote. And I agreed with what the senator said a while ago. Make sure who you're voting for. You do your research, you do your homework. Don't just listen to the TV or the paper or somebody saying, oh, vote for them. You better find out who you're voting for. What do they stand for? What will they do? How will they represent you? But I thought I knew a lot. But we got in that museum and I just couldn't believe it. I mean, I had no idea that had been a prison for the suffragettes. I knew they went to jail, but I had no idea that they'd been in that prison for that length of time. I think about 14 months. It was cold and no blankets, and it just gave them a little thin piece of material to wrap up in, and their food had maggots in it. And I saw those little bitty places where they were locked up. And then when they went on a hunger strike, Alice Paul and the others, they went on a hunger strike, quit eating. Then they started force feeding them. And it was a huge tube in a can and holding them down. Then the blood started gushing out. I just can't imagine anyone in this country not voting and not voting the right way. And by the right way, that's you deciding, research that person. Is that the one you want to represent you in the White House? Is that the one you want to represent you from Nevada? Like I felt about Harry Reid. It was easy for me to come to Nevada and campaign for him because the opponent he had was going to vote out Social Security. Well, that's the main income I live on today. I couldn't afford to lose my Social Security. I couldn't afford to have any cuts. It's low enough as it is. So I had to fight for Harry Reid to get him up there because I didn't want to lose my Social Security. But I make sure today, when I vote for something, I used to be guilty of not taking it serious. And I never dreamed that a Supreme Court justice would change my life. But we should never take voting rights, we women, for granted. We should always adhere to that and make sure that we research and vote during the elections. No matter how small the election is, we need to be there. If it's a runoff and there's just two people, we need to go vote. We need to make sure that who represents us is who we vote for. Because those women, some of them walked out of their homes and their husbands locked the door. They wouldn't let them back in. They lost their families. They lost their husbands. All they had was what was on their back. And they marched, got arrested, was sent to prison for 14 months. That just broke my heart. I can't get over it because I knew they went to jail and I thought, well, that wouldn't be too bad to go to jail for a couple of months. But that was not what it was like. And Zoe can tell the story better than I can, but I was just so shocked at that.
Well, they filmed it, so we'll see if it's in the movie.
Oh, absolutely. I have sent those pictures, those snapshots to many, many people. This especially during a presidential election, because you see what happened to Lilly Ledbetter, a Supreme Court justice. And probably had Sandra Day O'Connor still been on the bench, my case would have probably went on through. Then no one would have ever heard of me or any talk about equal pay. It would probably, but it wasn't a lot of money by then for me, because by the time I got to Supreme Court, my 3.8 million had dropped to 360,000. And the law firm would have gotten 50%. And I'd already spent about 40 of my own money. So I figure I'd probably broke even. I wouldn't have gained anything if I had won. But it was critical that we vote people in that pick the right people and do their jobs properly.
Thank you.
This has been such a joy to be with you ladies again tonight. This is like a fun time for me.
It's been a fun time for us too. You could see all the people in the chat are saying how impressed they are with all the wonderful speakers and all the amazing activism that you've done. Julie explaining, as people are putting in the chat, that you've made things much clearer for them on topics that a lot of us are ERA activists and we're learning something new. So
yeah.
Thank you so
I
much.
still believe ERA would make a lot of life much easier for women and minorities. It would really be, it'd be something that'd be just the letters, equal rights. I mean, that's powerful. And for it to be for everybody, I don't see how anyone can argue against it.
We can't either, can we, Zoe?
No, a few of the at Long Beach Suffrage 100 are still with us, and I want to tell you now, I'm so excited that I got to share these women of Nevada with you. Whenever I think of Nevada now, I am really all over myself about the fact that the inertia of that vote, the Equal Rights Amendment passed in Indiana, of all places, in 1977, and nothing happened, even though we marched by the thousands for that lousy 3 years and 3 month extension. Nothing happened in that period. And as you know, I was in the balcony with the Illinois vote in 1982. And I don't know, it was just unbelievable how many people had collected around it. And then once it was lost, they dispersed. And I learned so much about activism that when people think it's over, the majority disperse and go home like it never happened. To bring that possibility out of the mothballs, I know Helene, who walked across the country. I know she met Jeanette, and Jeanette talked to Senator Spearman, but to be in the presence of the women of Nevada that somehow broke what I call a mountain of inertia. And it escalated. I was in Illinois, in Springfield, the following summer, just after they had passed it. And the fabulous Lou Lang, who got it in motion in Illinois, and his daughter, Becky, who had bugged him constantly, Dad, you have to do this, Dad, you have to do this. And finally to be in Virginia, we have 38, and we need to hold their feet to the fire. That what they asked us to do, we did. We got a supermajority. It was legitimately sent out to the states by both chambers of Congress. And we need to have the Constitution include all Americans. There is no please, there is no I'm sorry, there is no what can we do? No, we've done it. And now we demand that David Ferraro at the National Archive publish this, and we start working it through the courts and get us activists back out on the streets, back in front of the Supreme Court. I'm going to be standing with Lilly and Jerry at the Supreme Court, demanding every time the application of the Equal Rights Amendment comes up. I want to tell you one thing that just is so amazing. When Amelia Fry asked Alice Paul in 1972, she was interviewed, and Alice Paul hated speaking, and I think it had a lot to do with her vocal cords got so seriously damaged when she was being force-fed in England. And Amelia Fry wanted to interview her, and Alice said no. And Amelia Fry wanted to interview her, and Alice said no. And honest to God, on the steps at 144 Constitution Avenue at headquarters of the National Women's Party, Amelia Fry sat down on the stairs one day, and Alice came to the door and said, what are you doing? And Amelia said, I'm going to fast till you give me this interview. And they interviewed, Amelia interviewed her for 8 hours. And you can hear it. It's all online. When you hear her voice, your heart will explode. And one of the questions Amelia Fry asked her is, what do you think the ERA will do? Now, this is 1972, right? Alice is 87 years old. And Alice says, well, I don't really care. That isn't the point. How the courts apply it and how the culture applies it. What happens to it as it is expressed in the culture and in the courts It's none of my business. I've given my life to equal rights under the law in the United States Constitution, and how they interpret it at that time is up to them, not up to me. And I thought that really captured for me how the United States Constitution and that constitutions are meant to breathe with the culture of the people, and the people that really have the needs that surface and bubble up through the courts that get decided by the judges. So anyway, it's been a great day, and I cannot resist thanking Nevada in particular for everything they did, all you women of Nevada, to make this happen for us. Thank you so much.
Thank you. We remembered the great Frederick Douglass, abolitionist in the 1800s. And what did he teach us? Power concedes nothing without a demand. It never has, and it never will. Let's show up for each other. We've got power in numbers.
Thank you, Jeanette. That was perfect. Thank you so much. And thank you, Zoe. For those who don't know, right when the pandemic hit, Zoe was about to do her Tea with Alice and me for Nevada Now. We postponed, and now we're finally, I think, believing it'll happen in October 3rd. I think we have on our event right now. I don't know if we gelled on that actual date in October. We're definitely having it. We've had Zoe to a few different programs, and everyone, she's now a member of Nevada Now, whether she likes it or not. Yeah, so we've adopted her. So thank you for spending all this time with us. I hope you enjoyed it as much as I did. It was such a treat. And happy Women's History Month. Happy anniversary of Nevada ratifying, and Jeanette's toasting. And so we will keep working on this. We will get this over the finish line all together, all of us. So, and we will be wearing our ERA masks. So
I got one.
We said that, yeah, Lily, I hope you have. We need to send.
That's a good one too. Very good.
So, and and Vivian has hers on. Thank you, Vivian. So, it's so great to see everyone, and thank you so much.